time to start. So hello everybody and welcome to PX Dermody's Funeral and Estate Question and Answers webinar. Today we are here with Bill Dermody, who, if you can see all three people, is the gentleman on the bottom of the screen there, and then Kristen in the middle, and then myself, obviously. I'm Katie Hrycun. Bill, would you like to introduce yourself?
I will. I'm Bill Dermody. As the name suggests, one of the family members who own PX Dermody Funeral Home. I'm also a lawyer, but I'm sure none of you will hold that against me. And I am live this afternoon from the basement at our home to try to cope with this 40-degree heat. The mushrooms haven't started to sprout yet, but it's just that time of year.
And Kristen, would you like to say hello?
Hello, I am Kristen Ferby, and I'm a funeral director here at the funeral home, and have been here for about 12 years now, I would say. So do a little bit of arranging at-need funerals and pre-need funerals as well.
And then I'm Katie Hrycun, as I said, and I'm the pre-planning funeral director and the aftercare specialist. So I help people make their pre-arrangements or organize their funerals while they're still alive. And after people pass away, then I help their family try to navigate some of the paperwork, like the government stuff or identification, helping with Canada Pension or canceling any health cards or anything like that. So, today we're going to begin this webinar with a few example questions, some of the top ones that we get. And I had said on the previous slide too that it's funeral questions and misconceptions, because lots of times we see people coming in with a thought that has been kind of skewed in the eye of the general public. So we might be able to add a little bit of clarity to those too. So we're just going to start with going through some of the main questions that we see, and then by all means we're going to open it up. So if you have questions, please type them in, and Kristen's going to be manning the Q&A toggle on this webinar, and we'll be able to address anything. So just keep in mind that this is going to be funeral related, pre-arrangement related, and also estate related. And we've got Bill with his legal expertise to help with any of those. So if any questions in those three areas arise, then ask away. Okay, so first question that we have, sorry if our video kind of covers the script there. You can always drag our picture away to the other side of the screen if you want to see what the question says. And next time I'll make sure I line it up differently. So the first question is for Bill. And what we get a lot of times is families assuming that common law is exactly the same as being legally married. And what are your experiences with that, Bill?
So I'll give the answer right off the top. And the answer right off the top is no. Now, I don't want to, pardon me, alarm everyone. Common law spouses have many, many rights that the law in Ontario have provided to them. But there are some very unique differences when it comes to common law relationship and marriage in the event that someone dies. So let me start with the areas that would give a common law spouse some comfort. Our law makes it very clear that common law spouses owe each other obligations of support. And so as a relationship is maintained during one's lifetime, common law spouses, and typically we're referring to people who have lived together in a relationship of some permanence. Often it's 3 years or more, or in a situation where they've had a child together. Common law spouses have that obligation to support one another. Indeed, our legislation in Ontario and at the federal level as well allows common law spouses some rights that are virtually the same, if not identical, to married spouses. But where the big differences come about are in the following areas. Specifically, where one spouse dies without leaving a will. The common law spouse who survives does not have the same rights as a married spouse. Why? Because our law of intestate succession, or our law of dying without a will, treats a common law spouse differently. Spouse is only defined as a married spouse for the purposes of becoming a beneficiary. Means that a common law spouse only derives the rights that are either given to that spouse in terms of how property is owned, or alternatively, the rights that may accrue to a common law spouse for support and so on. I will sum it up candidly. If a couple is in a common law relationship, it's absolutely critical for them to have a will. It's absolutely critical for them to review and understand how they hold property. The biggest risks that we run into are, as I've already said, a common law spouse not being considered a beneficiary for the purposes of an estate where there is no will. And secondly, where property is not owned in the name of the surviving common law spouse. That's where we get really sad stories of common law spouses being asked to leave a home because it was registered only in the name of the deceased spouse. So there it is. The answer is no. There are some rights that are identical. Legislature has worked very hard in that regard, but there still are some great inequities. What's the solution? The solution is ensuring that you have a will, that common law spouses have wills, and that the common law spouses ensure that they've reviewed how they hold their property together, and probably also consider making some arrangements with respect to their estate and funeral arrangements so that there aren't any debates. Sorry for the long answer to a short question, but it's a fairly complicated area.
I didn't know all of that, so I just learned something.
There we are. There we are. And there are, just for those who may be interested, there are other dimensions to this as well. So, for example, if you are a common law spouse, the two spouses should get advice on what's referred to as the equalization or division of net family property in Ontario. Married spouses have that right, but that right is not accorded to common law spouses. And so that's where domestic agreements or cohabitation agreements can be made.
What was that called again?
So it's called the net equalization of family property, or division of net family property. That's permitted under the Family Law Act. So common law spouses should really sit down and chat about that and get some advice. They may wish to consult a lawyer. They may wish to do a domestic agreement or a cohabitation agreement to cover off their rights.
Very neat. So we'll go on to the next one, and I think this one's for me. So these are incredibly common questions, as we've obviously, I think everybody has seen that the rate of cremation has increased substantially. So when people come and talk to us and say that they prefer cremation as their choice of interment option, we have a conversation with them that a cremation container is something that's required by law. And often the reaction is, well, if I'm being cremated, then why do I need a casket? So that's why I worded it this way. I think that as people talk to us, I think in the funeral industry, we get jargon that we get used to, and some of that jargon is mandated by a law. And I think that the general populace doesn't necessarily even talk about this stuff often, and I don't think they really even need to know until they're dealing with us. So it's not something that should come up really in everyday life. But there is a difference between a casket and a cremation container. And so when a cremation is occurring, what is needed by law is the cremation container. So I think people often have a vision at first when we have this conversation that they need to buy, like a solid oak casket to have it cremated. So we need to explain that what a cremation container is a very basic structure for somebody to be placed into, to be taken to the crematorium. And yes, the cremation does occur in that container. So it is cremated with the person. So they do come in different forms. There is cardboard. Some funeral providers do offer cardboard. Some offer like an MDF material or like a plywood, not to sound crass. And then we have kind of a mix between the two. So it's partially cardboard with a solid structure in the form of an MDF, just in the parts where we need it to be a little more solid and reliable. So it is not something that the funeral homes are forcing on people to buy more. We often hear that we're making people buy things that they don't want. So it is a law in Ontario that somebody is transported and cremated, or transported from the funeral home to the crematorium, and it has to be a rigid container. So that's why there's a couple options to what funeral homes are offering, but it's why there is no option to actually buying it. Everybody must purchase one. So the interesting question that often comes up as we're having this conversation is once we explain that it's not the solid oak casket, but they still need to purchase a container for cremation, then right away our next question is, well, we don't need an urn, or we already have an urn. So that's, I feel like this is a multifaceted question that kind of, it goes down a little bit of a rabbit hole. So when we're trying to explain this cremation container that somebody must be placed in to go to the crematorium in, we want to be really clear that that's not the urn. So this is, the cremation container is what our whole body is placed into prior to cremation. And then the urn obviously is the smaller structure that can come in any variables and is not mandated by any law. So it's just a personal choice, but it is the urn or the container that somebody's cremated remains would be placed into after the cremation. So there's a bit of a chronological order to this. I feel like we have this conversation a lot with people, and I just was hoping that we'd be able to clarify it, and that if anyone has questions about this because of the chronological order, including the what's mandated and what's not mandated, feel free to ask more questions about this after when we open it up to everybody. But I hope it's been clear enough, and I think a lot of people will have this conversation at some point in time in their life because so many people are being cremated. So we'll go to the next slide now. And this is for Kristen.
So the next question is, who controls my funeral arrangements? And again, like the questions prior, it's a bit of an in-depth question, or a bit situational. So I guess I'll start by saying the two different types of funeral arrangements basically are pre-arrangements. So funeral arrangements that are done prior to the time that they are needed, or at-need arrangements. So funeral arrangements that are done at the time of someone's passing and at the time that the services are required. So pre-arrangements are pretty easy. It's pretty easy to answer that. Basically, if you make the funeral arrangements, you control your arrangements. Obviously, you can do them on someone else's behalf or for someone else, but whoever is doing the pre-arrangements or making the pre-arrangements with us, they control the arrangements. In an at-need situation, so when these services are required, it gets a bit more complicated and is a bit more situational. So we can break it down pretty easily, three different ways of who controls the arrangements. First, if you have a will, then the executor or the estate trustee that is named in the will would be the person who has the right to control the arrangements. Of course, that person can choose to defer that onto someone else or another family member if they wish, but it's the estate trustee or executor's right first. If there is no will, or for whatever reason the family can't find the will, The law does state that every person is to have a funeral in a timely manner. So whoever steps forward to make those arrangements is allowed to do so, and the law is pretty forgiving for these people who step up to do the right thing at the time of someone's passing. In the event of that situation and there's a bit of a contest, so say two parties would like to make the arrangements, then it goes back to the law of intestate that Bill kind of mentioned in his first question. So the law order says the following: if there's no will and no one steps forward to make the arrangements, or multiple parties step forward to make the arrangements, the first person that is legally allowed is the spouse, followed by the children, followed by the deceased parents, followed by the deceased siblings, and then on to other family members or friends down the order. So again, I know it's a bit of a complicated question, but pre-arrangements make it a bit more simple. You control the arrangements for yourself. At the time of a passing, if there is a will, again, it's pretty simple. The executor or the person laid out in the will is the one that would control the arrangements. And if there is no will, or for whatever reason they can't find the will, then it would go down the chain of whoever steps up, or the law of intestate, so spouse, children, parents, siblings.
And if anyone would like that list, you can let us know and we can email that out to you after. If there is any information from this that you'd like to be emailed out to you after, by all means, we'll do so. I know that list is a lot of people in a quick list. So if anyone needs clarification on that, we're happy to provide that. Thanks, Kristen.
I think just 2 quick points. Once again, you'll catch the theme that the planning through at least having a will that appoints someone to speak for you when you die, your executor or estate trustee, it means the same thing, your personal representative when you die, really simplifies this issue as to who can make funeral arrangements, who can speak for me upon my death. The second theme here, of course, is that beyond appointing somebody to speak for you on your death, it is always a great benefit to express what your wishes are. It's one thing for me to say, here, I want you to make the arrangements, but when that time comes, it's another thing for you to know what I really want. And there can be differences of opinion within families as to what those arrangements should be. So we're encouraging people, yes, make sure you put your will in place, but also let's make sure that you express in some way what your wishes are for your funeral or for your final disposition.
And then just to bounce off of that, we've said that in the last webinar, and I think we'll probably say it in every webinar, but placing your wishes down does look, it does appear in many different forms. So some people just write out what they would like to have and know that they're give copies of it to their family so that their family understands what they've wanted. I think that that's the number one hurdle, because a lot of people don't even want to talk about it at all with their families. So oftentimes we know in our head exactly what we would like for ourselves, and we never actually have that conversation with anybody else. It never seems like the right time to talk about it. So just essentially the right time is now. Just have that conversation with the most important people in your life. Write it down for them. And then it goes from there. If you know which funeral home you want to use, or you want a little bit more detail or option, obviously if you do it on your own with your family and you tell them what you'd like, then that's an excellent thing to have in place. But if you do talk to a funeral home, then what you'll find is that you'll be asked some of the questions that the government needs, be able to maybe see some of the options, get a vague idea of the pricing, and oftentimes that's all people want to do at the funeral home is get more concrete arrangements put in place where they know what the government's going to need, they know what their family's going to need to bring, and make sure that the funeral home has a file in place. So that's like the next step up to organization. And then we do find that when people are talking to us at the funeral home, either they're happy with having that file in place, or they're in the position where they would like to make a payment on that on the pre-arrangement file. And sorry, I'm bouncing around. A pre-arrangement would be something that would solidify the pre-arrangement, or prepaid funeral file would be something that solidifies the pre-arrangements and the effect of having the prices locked in at today's cost, and obviously relieving not only the emotional and organizational burden off the family, but also the financial burden. And that does show up in different variables also. Some people want to pay for everything in full. If people are in that position, then that's an excellent option. But most people do look at making time payments because most people don't have that total at their disposal to place on their funeral arrangements. So we often do see people look at making time payment arrangements. So to continue down that organizational path, there's definitely ways to alleviate the pressure from the people who are going to be controlling your funeral arrangement. If, like Kristen said, it's after you've passed. Obviously, as Kristen said too, that all those things are in your control when you're making these arrangements while you're still alive. That made sense. So the next question is for Bill.
So the answer is no. If there's no will, your surviving spouse just can't take over. When you die without a will, there are two questions that have to be answered. They're the two questions that a will answers. But since you didn't leave one, you have to figure out other approaches. Those two questions are, number one, who is going to speak for you, who's going to be your legal representative, your state trustee? And the second question is, where does all of your property go? Who are your beneficiaries, to put it another way? Our law covers off who are going to be your beneficiaries. And typically, if I die without a will, what the law looks to firstly is, do I have a spouse and children? If the answer is yes, then there's a division between spouse and children. If I don't have spouse or children, then the next question is, are my parents still alive? Failing my parents? Are my siblings still alive? And so on. It's going through, if you would, the various degrees of kin in your family. So the answer to who my beneficiaries are going to be is in the law. Succession Law Reform Act covers it. And indeed, if I only leave a spouse, and I don't leave a will, my spouse is going to be my primary beneficiary, my only beneficiary. But if I leave a spouse and children, and spouses often are not happy to hear this, if I leave a spouse and children and don't leave a will, then what happens is that the estate gets divided between my spouse on the one side and my children on the other, subject to a preference share. And often spouses, while they may just love those children, figure they should get the whole enchilada. And it doesn't happen under the Succession Law Reform Act. So there's the answer to the second question. You don't have a will. Can my spouse just take over? Well, the answer is no, because your spouse may not be your sole beneficiary. But remember that first question I asked, and that is, who is going to speak for you? Well, the law does not appoint anybody automatically to speak for me if I die without a will. What has to happen is an application has to be brought before the court for a certificate of appointment of a state trustee without a will. That's a lot of words in there. And typically people have to go and hire a lawyer to make this application, get the appointment made, and it usually costs over $2,000 to do these things. You can get a lot of wills, I tell people, for $2,000. So the spouse just can't take over. I die today, I have a spouse, she can't just be my estate trustee or my executor without making application to the court because I don't have a will. I want to make it clear, however, that if my spouse and I own property jointly, so let's say our house is registered in our joint names or we have a bank account in our joint names, then there's no problem there. The mere fact that I have died, my spouse becomes the surviving sole owner of that jointly owned real estate or bank account. And of course, nothing I've said would change any designation of beneficiary. So if I die, I didn't have a will, but I've left my RSP or insurance policy to my spouse, that money, those funds go directly to my spouse, and you don't need a will for that. But for the rest, you may have a problem. Spouse just can't take over.
So what happens if the deceased spouse has a bank account in their name only, and let's say automatic withdrawals are coming out of it that affect the surviving spouse?
So the answer to that really rests with the institution that holds that account. Why? Because the institution, typically a bank, a credit union, trust co, whatever, is the one that's responsible to ensure that the account be properly run. So most institutions have taken the following approach. Number one, they say, if there are pre-authorized payments for a reasonable period of time for the necessaries of life or your home, utilities, that kind of thing, we will allow those pre-authorized payments to continue, assuming there's money in the account, of course. The institutions have also said it depends on how much money is at stake here. If there is perhaps an amount of 50,000 or under in that account, so we're talking about the account that's been left in the name of the deceased alone, many institutions will accept an indemnification, a promise to make sure the institution doesn't run into any claims, an indemnification from the beneficiaries of the estate so that the account can be paid out that way. Otherwise, the institution is going to say, I'm sorry, but we need this certificate of appointment of estate trustee. And that's where the application has to be made. I will note, however, that most institutions, and this goes to that first aspect I talked about, how most institutions will continue to make payments out, will allow some other payments to be made at the time of a death. For example, certain funeral and administrative costs, most institutions will understand and pay those out of the account of the deceased. Okay? But it is up to the institution.
Wow, that was a good one. Thank you.
You're welcome.
This one, I guess, is for me. So this is another one that we see very often coming up when people are talking with us, either in a pre-arrangement setting or in an at-need setting, is funeral jargon for when someone's passed away. So it's in either instance, we see it quite often. So let's say, I'll use as an example, a pre-arrangement setting. So if we're chatting with somebody and they say, oh, I don't need to make any pre-arrangements because I'm already prepaid at the cemetery. Before I go too far in, yes, some cemeteries offer everything. Some cemetery companies are also funeral companies, and if you have a pre-arrangement with them, you might have it all. That's mostly just one company in our area. So the chances are that the pre-arrangements that are with that company and you have it all are probably fairly slim and worth checking over before continuing this conversation. So what is happening often is that people have their plot prepaid, their gravestone prepaid, or their cremation prepaid, or they have like a niche structure or a mausoleum, and so they know that that is where they're going to go when they've passed away. Even if they don't own property at the cemetery and they have the cremation prepaid, maybe with an urn, so they know that that's going to be the final result for their family. So it's excellent that that person has that organized that much. It's definitely needed in the end. That's going to be an element that everyone's going to need. But the difficulty that that arises here is, yes, you have a plot at the cemetery with a gravestone, let's say. My question to that is how are you going to get there? and who's going to do the paperwork to have you placed in that plot. And that's where usually when we have that conversation, there's a bit of a blank stare. So what happens when someone passes away is they need to come into the care of a funeral establishment of some sort. So right now we're a funeral home that is having this conversation with you. There are places that are more like direct cremation places. They're not technically a funeral home. By all means, they can help you the same, but you do need to be in the care of some sort of registered funeral professional. So what happens at that point in time, whether or not you'd like a funeral, whether or not you'd like a funeral, what you're going to find is, let's say the bare basics are, you want to be cremated and you want the urn to go home with your family. So what we still need to do is keep somebody's body in the care of a funeral establishment or a transfer service until the paperwork is completed to have that person cremated. And you need a funeral professional to help you do all of that paperwork and then take our body to the crematorium. And then again, to go back to my original example of I have a grave, I have a gravestone. So it's still the same thing. We need to bring someone into our care. We need to sit down with the family, or with COVID, communicate with them electronically to be able to complete all the paperwork and file it so that that person may be buried in that plot. It almost seems like there is often like a blank spot missing in the organizational process there, where we talk to people and they know that they're going to pass away and they know that they're going to be cremated and taken home with their family. And then there's that whole gap in the middle of how are you going to get from where you pass to the crematorium? And that's where I think this conversation is very important to have. It's interesting because it even happened to me a couple of weeks ago where a family had just gone through the whole process with us. They actually had a funeral service too. So we helped them not only organize the bare basics, we did help them organize the services, flowers, stationery, everything. And I was helping them in an aftercare setting, so with their Canada pension paperwork and whatnot. And I said to them, I've noticed that that your pre-arrangements aren't in place. I said this to the surviving spouse. And just when you're updating your will and you're looking at organizing everything for yourself down the road, to get through the process right now of grieving and doing all of the estate paperwork that is imperative now. But once that transitions into starting to take care of things for yourself, we can look at making those pre-arrangements too. And the family looked at me and said, "Oh, it's okay. We have everything prepaid at the cemetery." So it was quite ironic that after they had been through the whole process, that still was what was stuck in their mind, that everything was taken care of. So that's kind of what inspired me to make this question today, because I really do think that it's our purpose to be here to guide people and to educate people as much as possible. And I thought if they've been through all that and still felt that they were secure, then I feel like we should probably talk about it a bit more.
Well, it's interesting, Katie. We all have that need of wanting to give assurance to our family members and the people who are going to be there for us that, okay, I've taken care of things as much as possible. It gives us some comfort while we're alive. But I will say that what we run into both at the law office as well as in the funeral homes quite often is that the rest of the story hasn't really been considered. So to your example of people having the impression, well, it's all prepaid, what we're encouraging people to do is to walk through and see what those arrangements really include. Communicate in the case of cemetery property, for example, or mausolea or columbaria, communicate with the family about where that property is located, where the interment should take place, And then more importantly, who has the rights to authorize that interment? Because we do run into situations from time to time. We just had one last week where the cemetery is placed in a difficult position because everybody knew that the deceased, everybody in the family knew that the deceased was to be buried here with parents and so on and so forth, but the chain of interment rights holders had gone cold. And by that I mean it was not clear who had the right to authorize the interment in the cemetery lot. So we worked hard with the cemetery. We got some affidavits. We got some statements from some other people about the rights of and the wishes of the original owners of the property, who happened to be grandparents in this case. And fortunately, the interment of the community remains was able to take place in a pretty timely fashion. But we're encouraging people, walk through that. If the next visit you're going to make to the cemetery or to the mausoleum or to the columbarium, ask yourself, well, gee whiz, I'm going to go here. Well, okay, what's the rest of the story? What's needed to ensure that you've got the right to be interred there? And Kristen, I don't know if you've run into situations when you've been making at-need arrangements of where there's been perhaps confusion or doubt about where remains could be interred.
As you were talking, I was actually thinking about one that I had just about a month ago, and it went down such the rabbit hole. I ended up to a step cousin that was adopted at birth, and we were trying to track him down, and they hadn't talked to him in years, but just the way that the ownership fell, because a lot of people don't realize that it's all surviving children, and whether they're estranged or in a different country, or it doesn't matter, and you need signatures from every single one of them. And then if they've passed, then you go down to the next chain, and you really can get quite far down there. And you know, you can understand where the cemetery is coming from, because obviously having an interment of someone at the cemetery is not something that is easily undone. So they really have to make sure that if they give permission someone to be buried there, that that was actually what was supposed to happen. So yeah, it really is unfortunate. That situation was so close to not having the person be able to be buried with their parents, if you can believe it. And you know, I kept saying to the cemetery, "Come on, you know, it's her parents. Everybody knows that they were supposed to go there." But it doesn't quite matter. So in the end, it worked out very well. But it took a lot of work and a lot of phone calls and a lot of private investigation work on Google.
And again, I think that we can't stop driving this home enough, that this is a conversation and an activity that is much easier done before someone passes away.
Very much so.
Bill, I think I've heard you say before, correct me if I'm wrong, but I think you said it, and it really, I didn't even realize it years ago. If someone dies without a will, and even after you do the application for that big long name you said of estate trustee of a person without a will, or that it never can truly become the executor or the estate trustee.
Yeah, you're still, it's so much easier to do that will. It's so much easier to express those wishes. They don't have to be in the will. Through a funeral plan, through some notes, through a little bit of research, it just makes it a whole bunch easier. And believe me, if you don't know and you're the one called upon to make all these arrangements, in the case, Kristen, you're referring to, I remember it well, and all the calls you had to make. And by the way, the wonderful reception that you got from that very distant relative who was so gracious and so on, it was a very happy story.
Yeah.
But the reality is that those details weren't known, and so it took a lot of extra work.
Yeah. Yeah, he was so happy that we had found him, and he even drove down 3 hours, I think, to be able to see his loved one here at the funeral home. So yeah, it worked out very, very well, but it could easily not have.
Precisely.
Oh, that's so nice. Okay, so I think that's the end of all of our example questions. Kristen, do you have any questions that have popped up? And then anyone who hasn't placed questions into Kristen yet, and if anything has come up for you, then please feel free to place them in now.
Yeah, so I'm not sure if everybody can find it. I think it's exactly where mine is located. So at the bottom or the side of your screen, depending how you have it laid out, there should be a Q&A and two little question bubbles there, and you can submit your questions there. I don't see any questions yet, but we'll give everybody a couple seconds or minutes here. So honestly, you have you know, everyone here that could possibly answer any funeral, pre-arrangement, estate question that you may have. I know people sometimes are a bit shy to ask their questions, but I know on the last webinar that we did, as soon as, you know, some of the questions started coming out and people were like, oh, okay, it's okay, I can ask a question now, then we really started getting into some really good questions. And it's good in this group setting as well with so many of you here, because one person can probably learn a lot from someone else's question.
Here's one that we did receive, and I'm going to paraphrase it so that it's just stated generally. And it has to deal with the situation of a divorce, but the will was not changed, nor were the beneficiaries on certain products, insurance to be precise. And so the question was, is the will terminated by a divorce? Are the designation of beneficiaries at the workplace life insurance terminated by divorce? And the answer to that is no. If you can remember, the rule is as follows. If you have a will and you marry, that will is revoked because of the marriage. If you are divorced, that will is not revoked. What happens is there's a provision in our legislation that says where a divorce has taken place, you read the will as if the divorced spouse, if mentioned in the will, as if the divorced spouse had predeceased. So the couple is married, the will is done, the spouse, the then spouse is appointed as the executor, the then spouse is appointed as the sole beneficiary. Individual, the couple divorces, and then one of them dies. The way that you read the will is if the spouse who was to be the estate trustee and the residual beneficiary has predeceased, so everything reverts to the alternates. Okay, that's how it works with a will. But that does not apply where you have appointed or named a spouse as a beneficiary under some kind of a financial product, specifically under life insurance, say through work or your pension benefits and so on and so forth. Most often there's a contest at least, and the spouse, even though they're divorced, the spouse who has been divorced may still be entitled to receive the funds, depending on the circumstances, and depending on whether there is a separation agreement as well. Should add that in. So hopefully that answers that question. And that was also followed by another question here about circumstances where spouses were separated at the time of the death of a beloved family member. The separated spouse has the cremated remains. We wish to inter those cremated remains in the family plot. The separated spouse says no, will not allow us to inter the cremated remains of our loved one in the family plot at the cemetery. What's the answer to the question? The answer to the question is who controls the cremated remains? And Kristen has already outlined that when she did the piece on who can make funeral arrangements. So the cremated remains, the remains of the deceased, are notionally under the control of the executor or estate trustee. The executor or estate trustee always has the right to make the decision about where those cremated remains go. in this particular situation. If there is no will, things just get a whole bunch more complicated because it then is colored by who is making the funeral arrangements, because typically the contracting party would have the right to at least receive the remains, may not have the right to make all the decisions, but at least that's who possession would be given to. And then often that batting order that Kristen has given us, in the case of a contest or a dispute, that batting order comes into play: spouse, children, parents, and siblings. It's a very difficult position for families to find themselves in when they want the remains, either cremated remains or full body burial, to take place at a cemetery, and there's a dispute in the family, and there's no clear legal voice because there's no will or funeral prearrangements or cemetery prearrangements to dictate what's to happen. And that's the only ones I have.
Perfect. Yeah, we didn't get any others through, so that must mean that we answered everybody's questions.
Okay. Oh, sorry. Yep.
No, I'm just going to indicate that if you're anything like me, I'll always think of a good question way after. So feel free to either call us at the funeral home, or alternatively, I think most people have been given Katie's email, and Katie can answer your questions for you, or alternatively make sure that you get your questions answered.
Awesome. Well, thank you so much, Kristen and Bill. I've learned quite a bit, and I've been doing this for a long time. So
I know, that's what I always say. Every time I do a seminar with Bill, I learn a little piece every single time.
Well, listen, thank you, and thanks for all of the participation and the attendees today. Greatly appreciate it. We're going to try to have the recording put up on the Facebook page, if not the website.
Yep.
So if anybody wants to revisit any one portion of it, we'd be happy to have you take a look at it.
And I'll try put a link to it on our bio of our new Instagram page too. So if anyone here would like to follow us on our Instagram, we are PX Dermody Funeral Home, and we'll hopefully have it there too.
Thanks all.
Okay, thanks. Everyone have a good day.